How do you use a deed of release to settle a pay dispute or any dispute about money? Stick around and I'll tell you, this one's important. Hi, Simon here from the Contract Company. Contracts, that's what we do all day, every day, and sometimes overnight. Lucky us. I know, we are pretty lucky. Right, so you've got a dispute about money. Could be a pay dispute, could be any sort of commercial dispute about money. How do you use a deed of release? Well, you need to use a deed of release to have both parties release each other from any sort of future claim. So what that means is you're basically saying one party is going to give the other party some money, and the parties both want to make sure, especially the one giving the money, that they can't be sued by the other one for any transaction or any matter arising out of this dispute in the future. So basically, long-winded way of saying this party pays the money, they want that to be the end of it so that this party can never come back to them. So the only way to do that is to waive your rights in a deed of release or mutually release each other. So what that means is this party releases that one from any future claims and this party releases that one from any future claims, which means if one party, like this party, tries to sue that party in the future, this party can hold up the deed of release that's been signed and basically say, you've signed the deed, under the deed you've released me, so you can't bring this action. So that's why a deed of release is important, because it bars or stops those future proceedings. Now, one trick with the deed of release I found out the hard way is that you want to make it clear in the deed that any rights or obligations that are owing are contingent upon payments. Now, what does that mean? Okay, let's say there's two parties and this party agrees to pay this one $100,000. But they're not going to pay it as a lump sum when the deed's signed. Instead, this party is going to pay $20,000 a month for 5 months. So what has happened, or what I've seen happen in the past, is the party sign a deed of release. This party make one payment, doesn't make the other 4. Now the problem this party has is that this one is in breach of the deed, which means this one has the right to sue him for breach of the deed, because you're allowed to sue for breach of the deed because as opposed to the dispute that arose in the background. But the problem this one has is that because the amount to sue for is only $80,000, when I say only, that's a relatively small matter when it comes to court cases. Because it's only $80,000, these guys are going to be in a tough position trying to get that money from the other bloke. So a better way to do it is, if you are this bloke, is to make the mutual releases in the deed and in the future contingent upon payments being received. So that way, if one of the $20,000 payments is not received, then the obligations in the deed are dead or don't arise until such time as the payment is received. So it's a long-winded way of saying that deeds themselves can also be vexatious, or they can be troublesome if you don't understand the risks that can go wrong with them. But anyway, a deed is the best way to settle any sort of dispute between a party, or between parties I should say, and you do want to mutually release, i.e. each party releases the other from any claims in the future about that transaction or matter. Anyway, I hope that helps. If you have any questions about this one, give us a call, 1800 355 455 or simon@contractcompany.com.au. Thanks very much.